As an introductory matter, I want to state that I'm not the chair. I'm simply acting as the chair today to shepherd the meeting through and to work through the agenda. I believe one of our distinguished member, Vic Johnson, has been voted by the Senate as the chair, and we're just waiting on some additional paperwork for that matter. I also, because we have some new members, would like the opportunity to introduce the new members. I am a new member. Mr. Johnson is a new member. Ms. Gardner is another new member. We have two other remaining members, but we're such a small group that if I could start maybe with Michelle, just to introduce the board members once again to the attendees.
Sure. Hi, everyone. My name is Michelle Cohen, and I'm an attorney with the law firm Miles and Stockbridge, headquartered in Baltimore, Maryland. I reside in Howard County, and this is my second year on the board, and I'm here in part as a designated legal representative.
Deb?
Which Deb?
Deborah Gardner, I'm sorry. And then we go with Ms. Gardner. I'm going to my right.
Welcome to the audio conferencing center. Please enter a conference ID followed by. If you're the meeting organizer, press star now.
What is that? Good afternoon, everyone. I'm Deborah Gardner. I am a new member of the Compliance Board. In my regular day job, I'm the legal director of the Public Justice Center. I'm appointed by the governor as the person who was nominated by good government and media organizations. And as an advocate familiar with the Public Information Act and requesters under the Act. I'm serving in my personal capacity on the board, and I am a resident of Frederick County.
Ms. Moore-Carter, please, if we can get an introduction.
Great afternoon, everyone. I am Deborah Moore-Carter. I am a holdover from the prior board. I am representing Baltimore City and live in Baltimore City.
Thank you so much. Is it Mr. Johnson still? I don't see him, but I don't know if he's
still here. Hello.
Yes, if we can get an introduction, Mr. Johnson.
All right. I'm Nivek Johnson, representing Kent County, Maryland, District 36. Been on the board just starting, so I'm glad to be here. Glad to be involved.
Thank you so much, Mr. Johnson. As stated, my name is Samuel G. Encarnacion. I'm also an attorney, not in Maryland. I'm an attorney who's been practicing law in Pennsylvania almost for 30 years, but I'm also have lived just as long my entire professional life in Hartford County in Bel Air, Maryland. I'm also as my new term on the board. Now that we're done with the introduction, I also want to lead to another introduction, but also lead to another part of our agenda, which is to get an update from the Public Access Ombudsman, Lisa Kirshner, who is here. And if we can see her on, she's going to come on and I'm going to give a brief introduction. Lisa has served as the Public Access Ombudsman since 2016. She facilitates the Public Information Act related dispute resolution through confidential mediation. Since House Bill 183 took effect in July, all disputes that come before the board started with mediation. So that's where they go. So she's a wealth of information for us. Each year, the board invites her to provide us an update on the Ombudsman program. In addition, the board includes a written report from her as an appendix to the board's annual report. We intend to do the same again. So at this time, I'm going to ask you if you can give us an update.
Thank you very much, Sam, for that introduction, and thank you, board members, new and old, for the opportunity to give you an update today. I'm going to try to do it in a very summary fashion because, as Sam mentioned, I'll go into more detail in a written report, which I expect will be ready fairly soon. This year, fiscal year 2023 is the first full year in which my program has been operating in tandem with the board under the changes made by House Bill 183. I know the board members are all very familiar by now with the changes that have affected the board. But the changes that affect my program directly include that, as Sam mentioned, now all matters, all disputes must come through my office for at least to mediate them before they are even potentially board eligible. Mediations must now be completed within 90 days. Previously, I had no set deadlines. Now we're operating primarily under the 90-day deadline. And at the conclusion of each mediation, my office has to issue something called a final determination, which is a brief statement of the issues that were the subject of the mediation and what the outcome was at the conclusion. That document in particular is something that gets submitted to the board in the event someone files a complaint. In order to accommodate these changes, my office has tweaked, if you will, some of its internal procedures, as well as some of the ways in which we interact with agencies and requesters. In particular, we are now, it's necessary for us to be much more precise in nailing down what issues are coming to us, what issues are part of the mediation, what issues are not, and making decisions as we go along as to when we have taken things as far as we can take them. That is, whether continued efforts will be fruitful or not. So with that background, I'll try to give you a thumbnail of what, from my perspective, the actual experience has been over the full calendar year, fiscal 2023. There have been some very noticeable changes in some respects, which I'll highlight for you, but there's also a lot of consistency in other respects with aspects of our program, and which is very useful to know, because it signaled to me that when the board and my office did their joint report back in 2019 that led to House Bill 183, we made certain projections and estimations, and many of those are really being borne out by actual experience, at least in the past year. One big change for us is that we had a very steep increase in the number of matters that came to us in mediation. We had 275 new mediation matters open in the year. That was a record number for us over any prior year. We also had a record number of what we call, referred to internally as help desk matters. These are usually unilateral requests for assistance. Most of them come from agencies, but not always. And typically they are questions about the act or questions about a situation that may be problematic in an attempt to try to prevent a dispute. So we had a record number of these types of matters coming into us, 251, which gave us a total of 526 new matters. That is a lot for us because I'm the only ombudsman. Spencer Dove is the only administrator for both my program and yours. And as you know, your board has also seen an increase. So I think it's fair to say there's been a total increase across the board in the volume of matters that we are handling. At the same time, because we had less time to deal with mediations, we had to bring them to conclusion within 90 days. We saw a real shift in the direction of bringing matters to closure much sooner, particularly when we compare those timeframes to what was the case during COVID. In COVID, we saw long, protracted delays for lots of reasons, many of which just had to do with the circumstances of the pandemic and what agencies were required to do to respond to those circumstances. And we expected that to shift over time. But we had a very, very dramatic shift into a much shorter period of time. We were able to bring at least 84% of matters to closure within the 90-day period, actually in something less than the 90-day period, within 84 days. We were able to close 46% in 6 weeks, 68% in 9 weeks. This is a much shorter time period than we've had over the last few years. And given the volume increase, I think it shows that everybody, we have been running. We've been on that treadmill at a faster pace. Things are moving forward. This aspect of how long it takes to bring a matter to closure is important, not just because the statute says we have to do it in 90 days, but experience tells us that the longer people have to wait for help, the less usefulness this program has for them quite often. And number two, the prospects for a successful mediation go down. So in general, the kinds of disputes that we see they don't get better with age. So it's really important to be able to try to get in there quickly, assess the problem, and try to move it forward just as quickly as we can. If the length of time things are pending grows, we begin to see longer and longer queues. So something that we have our eye on very closely to see what if the future trends are along these lines. But we started fiscal year 23 with only 28 matters in our queue. We made a big push to bring that number way down because we knew we were going to have to be implementing new procedures, and we wanted to do our best to keep the caseload very manageable. We weren't quite sure what we would get. What's really significant is that for most of 2023, our queue grew. It grew steadily. It grew steadily over the period, but most of the months it was somewhere between 40 and 60. So, you know, in the scheme of things, that may not sound like a big jump, but having the difference between having 30 extra mediations in your queue or 20 extra mediations in your queue is very significant in terms of when I'm going to be able to get to something. I'm concerned about this in the sense that if this queue continues to grow over time, it will simply compound itself and we'll start to see more and more chronic backlogs, which means the program will become less useful to people and it would become perhaps less successful in terms of outcomes. One of the obvious things I think that could improve this situation is having additional staff. And that was something when we did the joint report back in 2019, we projected we would need. We estimated that we would need 2 additional staff. At that time, we were estimating we would need 1 additional lawyer and 1 additional staff, either in administrative or perhaps paralegal capacity. I continue to believe that is the case. And we have, I think, a trend over the past year that documents that. I think we've done extraordinarily well over the past year, but the critical point that I make is that it is not sustainable on the staff we have today, because if any one of the 3 staff have anything whatsoever happen, such as go out on vacation, become ill, anything else arises that might interfere with our ability to be present every day, things will back up very quickly. And so there needs to be provision made so that mediations can occur continuously, consistently, and with the best possible outcome. So let me turn to mention just briefly some of the aspects of our caseload that really show a lot of consistency with the prior years. One area in which we're seeing very consistent data is in the participants in mediation. Traditionally and historically, our requester group has been made up largely of individuals who have been making PIA requests and run into problems with an agency with whom they have some direct dealing. So their PIA request relates to something directly they are involved in doing business with an agency. A somewhat smaller but very diverse group consists of what I call professional or occupational users. And this includes a lot of different types of individuals and groups, including, reporters, media, attorneys, businesses, nonprofit advocacy groups, independent researchers. It is a very, very eclectic group. But what they have in common is that the purpose of their request is directly related to their business or their occupation. In terms of the issues that are coming to us, and I think this really, let me just back up on the agency side. We're seeing very consistent participation by agencies. We have a very high rate of consent to mediation. It's less than 10%. I think it's around 7% have declined mediation or gave us no response. Typically, when an agency declines mediation, it's because from their perspective, there's nothing, they have no flexibility. It could be, for example, a mandatory exemption. They believe it's very clear cut and they don't see any utility to mediate. We certainly don't want to waste people's time and do things simply for the sake of form. And so I don't think that statistic reflects anything untoward. Some agencies, on the other hand, in that same circumstance will say, we don't have any flexibility, but we'd still like you to take a crack at trying to have a dialogue with the requester about why we had to deny this. So in general, we're seeing a very high rate of consent coming from agencies. State and local agencies, once again, are very equally represented. When I say local, I mean both at the county level and at the municipal level. And we have a third category of agency, which we call it other, but what it really includes are school districts and law enforcement agencies, police, fire, and state's attorney's offices. And we kind of group them together because those categories tend to have clusters of issues that are similar to each other, similar types of exemption issues, and other aspects that they have in common. Significantly, that other category that I just mentioned, the law enforcement and school districts, is when you combine them, they are the single largest category. That's 45%. 45% of my mediations are with agencies falling in one of those categories. And they have some very unique issues. In terms of the subject of the disputes themselves, we saw a lot of consistency with what we projected in 2019. And in particular, in my view, it really demonstrates the need for the expanded board remedy. And in particular, for the board to have the ability to decide denials that cannot be resolved in mediation. 50% of all of the matters that came to me involved an issue with an exemption, with a denial, either a withholding of a record or redactions applied to a record. That was the single largest category of disputes that came our way. We have another kind of general category called, some of you are already familiar with this, we call them missing in action. These are the requests that have been made and where the requester comes to our program and says, I have not had any response to this request. More than 30 days has passed, and I have no response whatsoever. So we call those MIAs. That category went sky high during COVID. I think at one point I had about 2/3 of my caseload was nothing but MIAs. Fortunately, those have come way down. They're down to about 38% now, which is still very significant. We'd like to see it become a lot lower, but it's going in the right direction for sure. Another category we see quite a bit of is something called, we call it the partial / partial incomplete response. And this is where an agency is given a response, whatever it may be, may even have produced some records, but the requester comes to us and says, we think there are more records, or they answered part 1 of the request, but not part 2. Or sometimes they may say some part of the answers just isn't responsive at all. So those are issues with a response other than a denial. Fee issues are a pretty small percentage of my caseload. if you combine disputes about fee waiver requests being ignored or denied, and disputes about the amount of the fee estimate or actual fee, that is 15, that comes to about 15% of my caseload. 4% of matters relate to specifically to fee waiver issues. So that's a very small portion of the disputes that come my way. And then we have another catch-all category, 12% of other. And other is various and sundry other problems and requests and things needing clarification. This year, this past year, 2023 is the first year we have been able to systematically track outcomes. And these are and when I say outcomes, I mean the outcomes that are reflected in the final determinations. So our outcomes, by and large, are very consistent with what we projected would be the case back in 2019. Back in 2019, we did a very detailed review of our caseload, and we came up with some estimations about what we thought the distribution would be going forward in terms of resolved, unresolved, and matters in need of a board remedy. And that, over the past year, has largely played out. 67% of the matters were closed as resolved. 19% were closed as unresolved. There's another 3% that we classified as partially resolved. So if you combine unresolved and partially resolved, that's 22%, nearly a quarter of my caseload. In our report in 2019, and then in the subsequent legislative years, 2020, 2021, we were every time we looked at the caseload, we came up with the same estimates. It's going to be between 24 and 26%. 24 to 26% will have some issue unresolved that will be in need of a board remedy, and that's pretty much what this past year has shown. We're a little lower than the parameter at 22%, but the caveat I would give you is that the second 6 months of last year saw a much faster pace of matters being brought to conclusion with issues unresolved than the first 6 months. And that's something I think we're going to have to watch going forward to see if those projections continue to hold. We have a couple other kind of administrative categories for closures that don't fit into any of the above that I just mentioned, and that includes mediations where, for example, the party initiating it disappears from mediation. They disengage from the process, or sometimes they formally will withdraw their request for mediation while the mediation is in process. And then there are, fortunately, rare occasions where I terminate the mediation for lack of engagement with the process or some other difficulty in moving it forward. That other category is only about 11% of the matters that I have. And that's kind of the snapshot of the mediation caseload I've been working with. In addition to mediations, we've been doing, continue to do trainings apace on request and other kinds of outreach activities. We instituted a new training program we're calling the Brown Bag Lunch Series. We do this at lunchtime. It's all remote. We pick a topic that that we think will be of interest and that may need some deeper attention that we can give in a broader training, and we'll focus in on that one topic. And another feature of these that is different than our previous trainings is we have requesters and agencies together. We invite the whole world to come. And so we have participants who are coming from both sides of the aisle, so to speak. And it's my hope that over time, that's going to give rise to greater understanding on the part of both groups as to the types of, concerns, problems, issues that come up for others. Our next brown bag training will be in November. I don't think we've announced a specific date, but the topics we're going to delve into are protecting personal information and ways of doing that. Ways of when you can mask identities sufficiently and how to do it, how to consider doing it. It's an issue that comes up in my caseload quite often. Looking to fiscal 2024, We're going to continue to track our metrics very carefully, especially with emphasis on some of the categories I mentioned that we're concerned to see whether the trend holds, and if so, to what extent. And I am going to be pursuing the recommendation that we jointly made in 2019 for 2 additional staff. I think that's going to be really important to continued success of our programs. And that, I think, pretty much covers what we've been up to in the Ombudsman program. I'm happy to, if you have any questions, to talk more about it, or to do so at another time.
Ms. Kirshner, first, let me thank you for your presentation. Let me thank you for such a thoughtful and insightful report and update regarding even some of your recommendations. I do like to open up to the board members. If any of the board members have brief questions regarding any matter they might want to address with Ms. Kirshner. And Mr. Johnson, you have a question? I don't know if you were raising your hand. Yes.
Yeah, I just wanted to, I tried to write down those numbers. You said 67% were resolved and 22% unresolved. Is that what
22% had some issue that was part of the mediation unresolved. Specific 19% we classified as unresolved because there was no resolution of anything. Sometimes things come with multiple issues. So when I say something is unresolved, I mean we didn't resolve anything. We have another category called partially resolved, where we might resolve some but not all issues, and we had 3% of our matters fall in that category. So that's how I got the 22%. I said 22% of our matters had some issue unresolved.
Any other questions? Ms. Moore Carter?
Yes, good afternoon. Hi, Lisa. I had a question about the staffing issue, given the fact that people need to take time off, people get sick, etc. So how soon can the staffing issue be addressed, and what does it take to address it? Thank you.
I'm not completely sure what all is entailed to address it. I know I can't go out and hire people. I know that much. I cannot unilaterally solve it. My office is supported by the Office of the Attorney General. And so through the report that I'm going to be writing and including in your report, we will bring it to the attention of the Attorney General, including with recommendations. I am some years I'm invited to go to testify in Annapolis before a joint committee together with a representative of the board. And if given that opportunity, I will articulate that recommendation and be prepared to explain why we need it. And we will continue to document these exact kinds of metrics and their impact on our services. And the usefulness of this program to the public going forward, so that we can continue to bring it to the attention of people who have the authority to do something. I think I can't say that I would look to counsel and others for advice on this. I don't think. No, let me turn it another way. I think it would be necessary to have a legislative amendment to the act in order to have someone come in to, for example, be a deputy ombudsman to function in that capacity, because there's no provision in the statute right now for the Attorney General to appoint another ombudsman, or deputy or whatever you might call it. As far as our need for additional administrative support, which is quite critical, I think the burden of all the new steps has fallen most heavily on our esteemed administrator, Spencer Dove, who is just right now doing about 3 different jobs full time, without a day off or a vacation, hardly, I might say. I'm not sure that I don't know whether or not legislation is required. It could be done legislatively and through the budget process. It could perhaps also be done simply administratively within the Office of the Attorney General. So I don't speak for the Office of the Attorney General. I can't I can't forecast what the office would be inclined to do, or how they will view this necessarily. But I think there are some options and some play in this. But I do think that a legislative amendment would be needed to appoint something like a deputy for me.
I do have
Thank you.
another question, and thank you so much for the question, Deb. This is just a brief question. If you know, do you know why there's the record increase in the number of requests for mediation? If you know.
I do not know.
Okay.
I can't say with certainty. I will say that every time we do a training or some outreach, I see a bump up in new intakes. However,
Yeah.
I don't think that alone would account for the increased numbers. It may be that with the implementation of House Bill 183, the whole ADR process has become more attractive and more useful to people.
Okay.
And so that is, and so therefore we're seeing more folks come in.
Thank you so much. Thank you. Any other questions from the board members? Thank you so much again. Let me give you the thanks from the board. Thank you.
Thank you for having me.
You're welcome. Just following along with the agenda, and agenda item number 4 relates to the brief overview of the number and nature of the complaints for the fiscal year for this year, 2023. I'm going to ask Assistant Attorney General Sarah Clem to provide us some insight with those numbers, some statistics. These numbers relate to the draft of the annual report, has state and local breakdown, which the board can include in the report if we desire, the number of new complaints in fiscal year 2023, the matter in terms of whether it lacks jurisdiction, written decision to issue, again, state versus local, and the nature of the complaint. Ms. Clem, if I can also ask you to provide a little more insight as to those numbers and statistics.
Sure. So in fiscal year 2023, which began last July, since then the board received 33 complaints. That is a large increase over the previous fiscal year. I think the board received 19 complaints that fiscal year, and actually only ended up addressing 10 of those complaints. Most of the complaints it didn't address, the board lacked jurisdiction. So the complaint was about something other than an unreasonable fee higher than $350. And I should say too, that is sort of an important shift. This is the first fiscal year where the board has had jurisdiction over, in addition to unreasonable fees, also denials of inspection and failures to respond to PIA requests, as well as complaints by a custodian that a request is vexatious or frivolous or in bad faith. So new complaints was 33. Of those 33, there were 7 that the board lacked jurisdiction over. All 7 of those, the primary issue was that the the complainant had not attempted to mediate the dispute first through Lisa's program, through Ms. Kirshner's program. And that is now a prerequisite to filing a complaint. So all 7 of them had not attempted that mediation process first. In addition, I think there were 2 of those complaints also, the issue that was raised was not within the board's jurisdiction. The board has issued 18 written decisions in fiscal year 2023. Notably, at least 2 of those captured 2 complaints in 1 decision. So they were 2 complaints filed by the same complainant about the same agency. Of the 33 complaints that were filed, 7 involved a custodian that was a state agency, 19 involved a complaint where the custodian was a local, either county or municipal level agency. The nature of the issues raised in the complaint is interesting. So 20 of the complaints, the issue was a denial of inspection. So it could be a wholesale denial, it could be a complaint about redaction of information in a record, or a constructive denial, an argument that the custodian didn't conduct an adequate search to find all of the responsive records. So 20 of those complaints dealt with denials. 3 complaints dealt with a failure to respond. 1 alleged unreasonable fees. And then there was another complaint for which the board issued a written decision Ultimately, the board concluded it did not have jurisdiction because the complaint was really challenging the proposed search method. The search hadn't been carried out at all yet, and so the board concluded it wasn't really ripe and within its jurisdiction. So it's interesting just to note, though, that, you know, with the expansion of jurisdiction, there are all these new complaints that the board can review. There was only one in fiscal year 2023 that dealt with unreasonable fees. And then there are 6 complaints that were carryover, so that the board received the complaint in fiscal year 2023, but hadn't issued the decision as of the close of the fiscal year. So 6 of those complaints, I believe 2 of those the decisions have since been issued, and I believe 2 others are to be issued within the next week or so. And then there still remains 2 more to be finalized.
Okay. Does any board members has any questions? Okay. Thank you again, once again,
Sure.
for the report to the board. The next item in the agenda is item number 5, which is actually one of our main reason why we hold an annual report, and is to really review and discuss the draft of the annual report that's going to be submitted. We don't really have the time for me to read the report verbatim, word for word, but I'll take it section by section and hopefully give you a good understanding what the report says and the sections of the report. We're going to have another section for the more members to propose changes or amendments to the report, and that section comes next. If you look at section 1A, section 1A details the responsibility of the board, including the expanded jurisdiction that we have obtained. It also detailed the board current roster, if you look at that part of the report, and the recent changes in the board membership. For example, there are currently 5 members of the board, and it lists all the 5 members. Michelle O'Cohen Esquire, she's the citizen member. Deborah Lynn Gardner, the nonprofit Open Government. Samuel G. Encarnacion, myself, a citizen member. Mr. Johnson, Vic M. Johnson, the citizen member. And also Deborah F. Moore Carter. So that's listed on that section. So again, that section details the responsibility of the board and the composition of the board and the expanded jurisdiction. If you look at section 1B, it details the board processes and procedures. The section goes through the complaint process step by step, the step-by-step process. The information tracks the board's regulations, which were adopted last year. If you go to section 1C, it provides information on complaint and decision activity for fiscal year 2020 through 2023, very similar to the presentation that we're just given in terms of the statistic and those numbers. The section provides information about the complaints that are dismissed due to lack of jurisdiction. We heard about that just now, and the 6 complaints still pending at the end of the fiscal year. Finally, the section provides short written summaries of each of the board 18 written decisions. And that's the review of the report, basically the draft annual report. Does anyone have not so much questions on this, but anything that they would like to add about the review of the report in terms of the board?
Yeah.
Yes, please go on.
I just wanted to sort of point out, and I think second what we heard from Lisa, the number of cases that we've had before us has increased significantly, and I do think it's due to the changes in the law that allow petitioners to approach us for things other than just the fee review, which I think is helpful. I think that these changes really help us to do the work that we're supposed to be doing, which is to facilitate publication of information that is helpful to residents of the state. I would expect that would continue. The other thing I just want to mention, because I will forget to do it later, is to add my thanks to Sarah and to Spencer for all of the work that they do, because our job would be that much more complicated, difficult, and time-consuming were it not for all of their efforts before we even see the cases, and then for their assistance in documenting our responses.
Ms. Cohen, those remarks are well delivered and welcome, and thank you for stating our gratitude to both staff members. for the board, and you're absolutely correct that the work that they do is invaluable and crucial to the function of the board. Also, your remarks are perfect segue to our next agenda item, which is our discussion of potential improvement to the PIA. And I'd like to say here that actually that section 41A04 requires the board to make recommendations to the Public Information Act. And that's one of our duties that we have, which govern the board's mandated reporting that requires the board to submit a report to the governor and the General Assembly, amongst other things, recommend an improvement to. So that's one of the statutory language and part of our mandate that we have. I understand that last year the board did not make any specific recommendation because of House Bill 183, which enacted significant changes, has just taken effect on July 1st of 2022. So having said that, the board is now more than a year into those changes. Do any of the board members have any recommendations and suggestions to discuss?
I guess one thing I would say, Sam, and this is not a recommendation, this is our first year with the expanded charter and expanded responsibilities. And I think that in some of our deliberations, we've had some robust discussion. And I would envision that even if we don't have specific recommendations in this cycle, that is something that we may want to focus on over the course of the next year as we get more comfortable with the nature and scope of work that we now have before us.
Okay. That seems like a very reasonable plan. Any other comments in the terms of any recommendation or suggestion, or it could be in the terms of the comments made? Yes, Ms. Carter.
Given my HR background, I'm still focused on staffing, so I don't know if it's appropriate here, but I would recommend that the board do whatever needs to be done to increase the staff.
And just to provide more clarity, staffing as to the ombudsman, as it was suggested that she would like either a deputy ombudsman and also a paralegal, to be specific. Yeah. Would that be in the nature?
Yes, sir.
Yeah. Sorry, I could ask you, is that a suggestion that we can make as to there? Is that an independent? If you get my question, it's Sarah there.
Sure. Yep. Yes. So I will say we in the public access unit, so Spencer and me make up the public access unit of the Attorney General's office. We support both the board and also the ombudsman's program. Perfect. So, and given the integrated nature of the two programs, I really think, if we get an additional administrator, that administrator would support both. If we were to get, a deputy ombudsman, obviously would work in Lisa's program alone, but any additional staff to the public access unit would be supportive of both programs.
Okay. Any other recommendation or suggestion? The next item is actually to make a motion, and I'll try to make a motion with Ms. Moore Carter recommendation, but I want to stay in the discussion is there any other recommendation to be made?
Does Deborah still have her hand up?
Oh, that Ms. Gardner? We can't hear you. We cannot hear you.
You're on mute.
Sorry about that.
Yeah,
I do. I think one of the things that we've seen already during this year where the board has had jurisdiction over denials of inspection is some shift to attention to the fees and fee waiver requests and fee waiver denials out in the community. That is, there are more, I'm certainly seeing more agencies quoting very, very large estimates that stand as an obstacle to access to public records. And I think often during the mediation process, it appears that they are reduced quite a bit through the good offices of Ms. Kirshner. But they do still stand as a delay. You know, they create a delay in access to records. They create a and often even a reduced fee will stand as an outright barrier to access to records for members of the public, and whether they be organizations or individuals. So I would like to see the board recommend that it have jurisdiction over fees and fee waiver denials. This was included in HB 183, but it didn't. That particular portion did not pass, and I do think it would be an important function for the board, in the same way that the board has begun during the last year to grapple with the denials of inspections of records.
Okay.
And the other core functions of the Public Information Act.
Thank you, Ms. Gardner, for that. I think any other suggestion or recommendation before we move to the motions to vote on the recommendation and to move on those recommendations? Okay, let me see if I can restate it. Ms. Moore Carter, if you have, if I misstate your motion, please correct me. But I believe it's to increase the Public Access Ombudsman Office staff to include an additional attorney in the nature of a deputy ombudsman and an additional paralegal. Would that be the motion?
That is correct. That is
Okay.
correct, and that would be my motion.
Anybody will move that motion or second that motion?
I have an amendment that I want to make to the motion.
Okay,
So
what's the
I'll
amendment to the
second it.
motion?
I'll second it, but then my amendment would be just to clarify that as part of the staffing increases, we should consider whether it's possible to address that, not solely for the benefit of the Ombudsman's office, but maybe the second person would be an administrative person who could support both the Ombudsman and the Access Department generally.
Okay. With that change, and that's upset to Ms. Moore? A friendly amendment?
Yes.
Okay. All those in favor say aye?
Aye.
Or was any more discussion? Mr. Johnson, I'm sorry.
No, I was just aye.
Oh, okay. I think that motion and recommendation is adopted. Ms. Gardner, I'm going to try to state your motion recommendation, which is actually to amend the Public Information Act to expand the jurisdiction of the subject matter of the act to include jurisdiction for fee waivers and denial of fees. Would that be correct?
Well, it would be expanding the jurisdiction of this board, of the compliance.
Of this board, yes.
Yes.
But regarding amendment of the law, correct?
It would, in fact,
Yeah.
yes, and to cover not just reasonableness of fees, but fee waiver denials in particular. Yes.
Any discussion as to that motion?
I have a question. Is
Yes.
the motion to request that the legislature do that? Because I mean, we obviously don't have the ability to.
It would be, yeah, that's what I mentioned. It would be a legislative fix. They would, basically, I think the motion is to amend the statute, the Public Information Act, to give us that jurisdiction, right?
Let me try to be as clear as I can, and I apologize for not having done so earlier. My motion would be that the board include in its annual report a recommendation to the legislature to expand the board's jurisdiction to cover fee waiver denials.
But Ms. Gardner, just to be clear, that change will have to take place by changing the act, correct? The Public Information Act. Okay. Mr. Johnson, question?
So yeah, I just want to be clear for making sure I'm clear. This is to say we get a case where, so you're, to make sure I understand, this is for if an agency or any party decided not to approve a fee waiver, you're asking that to be those types of cases to be brought forward as well.
Yes.
Is that what I'm?
Yes. Because now the only recourse is to go to court, which is obviously more expensive and more time consuming. And so it would make the process, which is meant to be swifter and more user friendly, of the compliance board complaint and hearing process, it would make that applicable to fee waiver denials in addition to its other jurisdiction that it already has.
Any further discussion, or if you want to second her motion?
I'll second.
A second. All those in favor?
Aye.
Aye.
Any opposed? Anybody abstaining? The motion passes. Okay, I think this reflects that there were only two recommendations that came out of sort of our brainstorming and discussion, and both are going to be recommended and going to be part of the report. Now, the next item on the agenda, I'm going to reference back the board to the draft report. So are there any changes to the draft report here? Any amendments to the draft report or any discussion? Mr. Johnson?
Just want to note that I think one of the decision dates is incorrect.
Okay, if you can give me a page and page or paragraph.
I would say it's probably page 11.
Okay.
The 2304, it reads November 9th, 2023.
Okay. And the correct date should have been?
Should that read, I guess I'm asking Sarah, and should that be read November 9th, 2022?
Yes, yeah. Given that November 9th, 2023 has not happened yet, it should. Okay. I will make that correction.
Okay. There's another question. Go ahead, Mr. Johnson.
Yeah, maybe this was just a general question. What do we have? Does the public access for the Attorney General, do we just have a simple one pager of the process to show how a process starts from the request to the agency, to the ombudsman, and then to us? Do we just have like a clear like one page sheet that shows that process?
It's kind of a step-by-step summary.
Yeah,
you would like to see that included?
Not, I guess, not in the report, not in the manual, just in general as an informational reference for the public. I guess is what I'm.
So, I think, do you have any informational outreach community pamphlets or that is available? I know it's outside of the draft report, but it's a good question.
There is a Spencer created a one pager that sort of details the process of mediation, and we don't really have anything that details the board process in the same way, but we could take a stab at creating something. I guess that would sort of be a two pager then to kind of encompass both programs, but
yeah, I was just curious if there was something, but it would be nice if just the reference.
Sure. Yeah. I mean, the board's website does have step-by-step information, but it's not visual. It is just text. So
as a related note for the board on this agenda item, the board typically includes the ombudsman report as an appendix to the board annual report. Do we want to continue that? Do we think that's still important for that report to be included in that report?
Yes, and I would make a motion if that's necessary.
Okay, Sarah, this is something that requires action, or just this is normally included? Does the board have to vote on this?
The board usually does vote to sort of formally to include it.
Okay, who wants to make a motion that the ombudsman?
So moved.
So move. All those in favor? Or any discussion? Thank you so much. Anything relating to the report at all in any event, because we have to give specific instruction to make changes. They could be substantive too. I don't want to make sure that I give the board plenty of time if they have anything to express in terms of changes.
So this opens up for me a little bit of a broader question that I wanted to bring to the board. One, I think it would be helpful for us to get input from the public about possible recommendations that we might make, which might very well mean that we would need to have further discussion among the board if we get any recommendations from members of the public. And secondarily, in my prior experience attending board public meetings before I was a member of the board, I noticed that we rarely had time during the meeting for the portion of the agenda where we would receive public comment. And it looks like we're on track to have that same problem today. And so I wanted to suggest both that we accept input from members of the public concerning recommendations we might make to the legislature in our annual report, since we do have that obligation to make recommendations to the governor and the legislature. I'd like for us to consider receiving public input before we will make final decisions about that. And I'd like for us to consider scheduling our public meetings for a bit longer in the future, so we probably will then have time to receive information during the meeting from members of the public.
And Ms. Gardner, you mean today, to receive input today? Because I'm okay with that.
Well, I don't know whether we can do it today, because I suspect board members were prepared to meet only until 4 o'clock, but I'm not certain about that. So perhaps we should perhaps we should see what others say.
Okay. Sarah, do you have a specific instruction, Ms. Moore Carter?
Yeah, I think that I agree with the public comment, but I would like to have a process so that it is organized and won't become unwieldy.
No,
yeah.
I agree with that 100%. I would like to make time as much as we can, even for today, for comments. I tend to be as open and transparent. I mean, with time. I don't know if there was a time limit. Yes, Sarah.
We did, when we sent out the notice of the meeting, we did ask people to provide any comments they might have in advance, essentially to kind of register, although, you know, the board does not typically decline to let someone talk just because they didn't pre-register. So the board did receive one person who indicated that she would like to speak and make some recommendations, but we did not receive any other comments in advance of the meeting. I mean, there was a vehicle. I'm just saying there was a vehicle kind of in place prior to the meeting for people to provide input.
Am I right? There's going to be another public meeting before the report gets published as well?
Yeah. So the board the report has to be submitted by October 1st. So we're operating on a little bit of a tight timeline. You know, typically from this meeting, I will make the necessary substantive changes to the draft report, and the board would come together again before its due date to approve sort of a final version.
Okay. Thank you. And now that leaves us with the public comment. I believe there's one person who pre-registered to make comments. I'm okay with other comments are made. I don't know who that person is, but I don't know if that's something that is, I'm told, is that the person on the screen?
I suspect it is me.
It is, yes.
Sarah, was I? Okay,
So-
I just wanted to
So
make
we'll take your comments, and maybe we'll take some other comments as well.
Terrific. So thank you all for the ability to address and your graciousness in staying a little bit past time. My name is Rebecca Snyder, and I am the Executive Director of the Maryland, Delaware, DC Press Association. And of course, the PIA Compliance Board and open records is very important to journalists. Deb Gardner mentioned one of the recommendations that we had, the board jurisdiction over fee waivers, but I wanted to just note that in previous reports from the Compliance Board, you've noted that costs and fees really permeate the recommendations that you've made, and in your last annual report, especially around police records. And August 31st, the state Supreme Court released their decision in the Baltimore Police Department versus Open Justice Baltimore case. And so I, along with some other advocates, reviewed that decision to see where there might be gaps that might need a legislative fix that might be appropriate to recommend in the board. So although Lisa mentioned that fees are a small portion of the ombudsman's caseload, Deb Gardner also noted that when there are onerous fees, that usually stops a requester short. I mean, they either just give up or they file suit. And if you don't have the ability to file suit, you're back in the boat of giving up. So aside from the recommendation that Deb brought forward on board jurisdictions over fee waivers, Press has 3 more recommendations that we would ask you to consider.
Okay.
So there's a waiver in the public interest, and there seems to be a little sponginess about how that is applied across different custodians. And so we would recommend that the Maryland PIA match the federal FOIA definition of of fee waivers in the public interest. That would just, FOIA case law would automatically be invoked, and it would create a lot more clarity for custodians who really do rely on subjective criteria. So it's a big issue for reporters because reporters often are accessing public interest waivers. We also saw that as one of the complaints within the BPD decision. Secondly, mandatory indigent fee waivers. This creates so much confusion, and again, the inconsistencies around application in the custodian community creates some problems. So, and I feel like the board itself notices that. When we reviewed some of the recent decisions by the compliance board, we noted that the decision in Lewis Sims versus BPD saw that, and that was around unreasonable fees on the surface, and that the fee was initially something like $6,600, and it was reduced only by the consistent efforts of that requester down to about $1,600. But even that amount was an absolute bar to access for an indigent incarcerated individual. And the board itself encouraged custodians to grant indigency-based fee waivers. There is no standard by which custodians can figure out what constitutes indigency. So we feel like there should be a mandatory indigent fee waiver based on criteria that could be supplied. And then finally, the last piece around fees is that deposit versus pay up front model. So oftentimes what we see is that requesters are asked to pay this enormous fee, like Lewis Sims was asked to pay $6,600 before the requester or the custodian really understands what the final cost is. And every agency is different. Some require that money up front, some require it, after the request is granted. And some of the advocates that we discussed suggest that those large fees, and frankly, Press feels this as well, those large fees are used as a deterrent to requesters. Just straight out to say, we don't, it's going to be an enormous amount of money, so don't even worry about it. And so we'd like to see consistency across the custodian community, and maybe, suggest some sort of deposit down, but not everything up front, because that would make the system more equitable. And then all your money's not out when, if Lewis Sims had the ability to pay $6,600, and it wound up being $1,600, I'm not sure he would have gotten his money back all that quickly, but he's out of pocket during that whole time. So I think that those are 3 additional areas that the Press Association would appreciate the board considering in its recommendations.
Ms. Snyder, thank you so much for those comments, and forgive me if you've already done this, but would it be possible for the Press Association to write us a letter with those recommendations? So I make sure we get due diligence to your request.
Absolutely.
Okay, and you can address it to the board or also, and we'll make sure that we'll take a look at it and consider those suggestions.
Terrific. Thank you so much.
Okay. With the board permission, I would like to take any other comments, if that's okay, and then. If anybody else has any other comments or questions or remarks before we adjourn the meeting.
I just want to echo my individual thanks, not just to the staff, but to the Ombud. They all do extraordinary work, and I really do appreciate it. And just having had a couple of months or so to see what that work is like behind the scenes of the Compliance Board, I just really want to make sure they understand how very much we appreciate what they do.
Thank you, Ms. Gardner. Mr. Johnson?
Thank you. Yes, I just want to echo the thanks to the staff. It has been a smooth transition, and working with everyone and getting to know. I just want to know what our parting directions are after the close of this meeting, and what next steps are as well.
Okay. Mr. Johnson, can you mean what happens next after this meeting?
Yeah, what based upon we're coming back together, I'm assuming, to actually approve all the changes and things in the couple of weeks. Is that my understanding?
Yeah. Sarah, let me see if Sarah's still, in terms of the when, I guess we can request a board meeting in terms after I guess I think there's only one change to the draft, if I'm correct, which is the date.
Yeah.
Yeah.
Yes,
and
well,
then,
and then I will draft the affirmative recommendations that the board adopted at this
Okay.
meeting, the recommendations regarding staffing and the recommendation regarding board jurisdiction. You know, I will do that as quickly as I can. I would ask if, you know, the board, in terms of meeting again to approve, if the board thinks that the board may need to add even more substance to it, it may require additional edits and an additional
okay.
meeting to approve. So it would be on a pretty tight deadline.
Okay. So you're gonna incorporate the recommendations into the report and then circulate that for us to take a look at.
That's right.
Okay. Mr. Johnson, that's I was wondering the same thing. Is that sort of I get a response to your question?
Yes, and with the press association, you'll get us the letter. Correct?
Yes, as soon as that comes in, we will forward it to everybody.
And I'll
Yes.
send it this afternoon.
Thank you so much.
Thank you
And
very
with that in mind, if there's not any other, yes, Ms. Gardner.
Just one question for Sarah. Will we be able to have a board meeting in which we can deliberate over those requests and recommendations from the press association in time to make a decision about whether to include them in the report?
I think so. I mean, I think that as long as the board is able at that meeting to nail down the substance of what those recommendations are, I can draft them. If the board has like corrections for typos or wordsmithing edits, non-substantive edit, you know, you can send those directly to me. I don't think the board needs to meet formally to make those types of changes. And, you know, so with the idea that the board would meet and kind of adopt the substance of that report, that final report at that meeting. And then there may be some changes, typos and grammar, you know, that sort of thing, but that would be nothing more substantive would change after that.
Okay, so that wouldn't actually require a second meeting to formally approve the report. We could do that. We could do that by email.
Yes. Yeah. Well, I think the board would have to approve to nail down the substance enough. If the board is adopting additional recommendations, that has to be done at the public meeting. Yeah. Again, the form of that recommendation takes, the wordsmithing, things like that, that can be done, I think, over email.
Good.
Thank you, Sarah. With that said, if there's any other question or remark, I would like to bring this meeting to a close. I would like to make some just brief closing statements. I want to thank all my board members and remind all the attendees that these are volunteer board members, just citizens doing a very important function for fellow citizens. And with that, I would like to adjourn the meeting. Thank you for your participation and your work. Thank you.
Thanks for running the meeting, Sam.
Thank you so
Yes,
much.
Thank you very much for
Thank you.
chairing.
Thank
Thank
you,
you.
everyone. Take care.
Thank you.
Yeah.
Good afternoon.